Okay, so I'm gonna start off here. So basically, in the listing agreement, it's a 4-page contract that you are um filling out to properly list the property for sale on the MLS. So it's a standard form. We have it on our transaction desk. If you guys are all don't have transaction desk, I'm I believe all agents currently working at Lifestyle have access to their own transaction desk. So uh this is the one you guys want to use. You guys want to use the ERS 18 TB. This is the listing agreement that I use all the time. Okay. So this listing agreement here, it's 4 pages. It's a very simple form. We can go through this training quick. Um, so basically here, it's going to describe the seller, whoever the seller of public records is. This is the seller that you're going to put on the from public records. Um, if it's two owners, you're going to want to have to put those two owners, and you're going to also um, sometimes lock the fields. If you didn't go inside and go through the steps of adding all the information to the property, um, there's a tool here that you guys can go to, and where it says, I believe, you have your your information for the transaction. Um, I would have to exit this, but if you go back and you work around the system, you can go ahead and input the information of the seller and the property, and it auto populates it to every form that you're going to download for the transaction. So here we have the exclusive right of listing agreement is between the seller and the broker. So you're going to put the seller's information here, you're going to put the broker, and then you're going to put your terms, uh, your time frame. That's you can always add your name here on line 3 as well. I've done that before, where I put Lifestyle International Realty slash um I could put slash Miguel Rodriguez PA. Sometimes it familiarizes the seller with the agent that they're working with, and at times I always do it most of the time. The authority to sell the property, seller gives the broker. This is basically authorizing you to sell their property. You always need this document fully executed, fully filled out to the best of your ability, with everything that is provided here. All these questions, you want to answer them as much as possible for between you and the seller at the time of signing. Here you're going to put the date. You can do a 6-month term, 12-month term. I typically do a 6-month term, or 12 months. I do 6 months when I know that I'm listing the property at a reasonable market price. So basically, this is going to allow you, it's going to give you the terms beginning on such date and terminating on such date. Upon full execution of the contract for sale and purchase of the sale of the property, all rights and obligations of this agreement will automatically extend through the date of the actual closing and sales contract. So if you have this filled out to, let's say, October 1st, but you went into contract in September, okay? But let's say the closing was extended, closing is taking place after this expires. Upon full execution of contract for sale and purchase of property, all rights and obligations of this agreement will automatically extend to the date of the actual closing of the sales contract. So it basically tells you this is extended through the closing date of your sales contract once you have it executed. Seller and broker acknowledge that this agreement does not guarantee a sale. This property will be offered to any person without regarding race, color, religion, sex, handicap, familial status, national origin, or any other factor protected by federal law. So basically, this shows no race. no color, religion, sex, exactly what's described here. Seller certifies and represents that she is legally entitled to convey the property and all improvements. So here comes the description of the property, the address. You want to put the city, state, and zip code. You got your legal description. You want to put also what's included. And this is very important because I put as is because most of these houses that I'm selling are either vacant or the sellers typically have them ready to vacate or ready to finish the construction. But if there's appliances, you want to include these appliances. You want to put what's included in these appliances in anything. If there's a light fixture that you see in the ceiling when you come in through the front door, there's a chandelier, you want to put front door chandelier. You want to also, if it's not included, you're going to specify that on the listing agreement. At the end of this listing agreement, I'll show you guys where. Occupancy. If the property is currently or not currently occupied by a tenant, if it is occupied, the lease terms expire on such date. You want to put this here and you want to get a copy of that lease. The property is offered for sale on the following terms acceptable to the seller. The seller this is the list price. This is your list price, what you're going to sell it for. If you ever need to change the list price or you need to lower the list price for whatever the case may be, you need a written notice from the seller and to have the seller send you something in writing. And it can be an email. You can create a status change. You always want to have the status change signed by the seller as well, just in case you ever want to change the status on the sale, which would be the listing price. Financing terms, if they want to take cash, conventional, VA, FHA, whatever they want to take. If the seller wants to finance or hold a purchase money mortgage, this is what you're going to put. You're going to put seller's financing and you can put their terms here. The seller is willing to loan, let's say 50% of this. So at 50%, I would put here about 650,000 more or less, or 594,000, around 590 something thousand. We would go ahead and put that in here, what he would want to finance his terms. If there's an existing mortgage that they want to allow buyers to assume, they can assume this mortgage. Obviously, the buyer will need to get qualified and go through their current mortgage. But a lot of times I've seen this before, especially when sellers have gotten into loans 3 or 4 years ago and the rates are lower. The mortgage term is for such and such long time, and you'll specify the interest, and if it's fixed, it's an assumable, it could be an assumable existing mortgage. The lender approval is required most of the time. Okay, basically here, seller will ensure that mortgage payments and required escrow deposits are current at the time of closing and will convey the escrow deposit to buyer at closing. Extensive regulations affect seller financing through finance transactions. It's beyond the scope of real estate licensee's authority to determine whether the seller is financing agreement comply with all applicable law, whether you must be registered or licensed as a loan originator before offering. Seller financing. You are advised to consult with a legal or mortgage professional to make this determination. Basically telling you, you want to reach out to a lender or a loan officer to make sure that this can comply and with the seller. Seller's expense, seller will pay for the mortgage discount. Basically, you don't see this too often, guys. Okay, I've seen it, but you don't see it all too often. Broker obligations, going to talk to you about the broker obligation. Broker agrees to make diligent and continued efforts to sell the property in accordance with this agreement until a sales contract is pending on the property. Your diligent efforts and continued efforts means any way that you could try to sell the property through social media, through the MLS, open houses, and we'll get more into that now. The multiple listing service, placing property in the MLS is beneficial to the seller because the property will be exposed to a large number of potential buyers. It's this section here describes the MLS and what the MLS is, will be published according to the MLS, unless the seller directs broker otherwise in writing. Seller authorizes broker to report to the MLS the listing price, terms, and financing information on any resulting sale for use by authorized board association members and MLS participants and subscribers. Brokers authorities. Section 6. Seller authorizes broker to market the property in the public unless limited in paragraph 6B. So if the seller does not want the property for it to be authorized in public, you can select this section right here. Seller does not authorize the broker to display the property on the MLS. If they just want you to sell the property, and I haven't seen a seller that would want to do that, but if you do run into it and the seller does not want to let you list the property on the MLS and they want you to sell it through social media, a for sale sign outside the house, whatever the case may be, seller understands that if the seller checks option 60, if for sale will not be placed upon the property. So basically, if they select this section to not be displayed on the property, the for sale will not be placed upon the property. Seller understands and acknowledges that if seller checks option 6B, broker will be limited to marketing the property only to the agents within the broker's office. So here it's basically describing that you cannot put a sign outside your house and you cannot list it on the MLS. You can only sell the property within your broker's office. Basically that would be an in-house listing agreement if they do want you to do this. I typically don't see this as a normal thing, but it could happen, and this is what you would have to select. Okay. If they don't want to display the property, if they want to display the property on the internet except the street address, you would select this section. Typically, you don't select none of these two because you want to put the property on the MLS and you want to display the property address. Okay. If you want to use a lockbox system, let me go back here. Provide objective comparable market analysis information to buyers. So basically, you want to give a CMA to buyers when they basically have information. The MLS automatically does that. So buyers go into the property on the MLS, or a realtor sends it to them, and they typically send them some comps to show them the market area. Check if applicable. Use a lockbox system to show and access the property. A lockbox does not ensure the property's security. So this section would be selected if we're gonna allow us to put a lockbox on the property. Seller's advised to secure or remove valuables. Seller agrees that the lockbox is the seller's benefit and releases the broker persons working through a broker and broker's local realtor board association from liability and responsibility in connection with any damages or loss that occurs. So if something gets stolen, if something gets lost with a lockbox at the property, basically you're not held responsible. A lot of the times what I do on a normal basis is I would put a super lockbox on a listing. A super lockbox, you can get it from the MLS, from the board, and it's an electronic lockbox. Everybody has access to it. If you're a realtor, when you sign up with the board, get yourself a super key, and it's going to give you access to a lot of properties that typically most of them have a Supra. If they don't, they usually list them. The agent usually puts a lockbox, or most of the time a Supra key lockbox. So you access it through your phone, through your Bluetooth. It basically, sometimes it'll ask you for a code, a CBS code, so you can access it that way as well. I protect a lot of the listings that we list with a Supra key lockbox, because it also records the agents that went into the property. and the code cannot be given out to a buyer. So it's not like a buyer can, if you put a regular lockbox, the buyer can, a realtor can sometimes, now I'm not saying all the time, and it shouldn't be this way, but they'll give out the lockbox code. And this just actually happened to me. So it's very important to always change your lockbox when you have a property um, in an area that you give out the lockbox combination, and it's not a Supra. You want to go buy the property and change the lockbox code every so often, just because I've seen it happen in the industry where agents have given out the lockbox code. And it's not something that should be done. Um, but there's agents out there that have done it and sent their buyers directly, especially when the market was very, very hot. Agents had a lot of showings and they couldn't just make it to everything. That happened a lot. Basically here, if we continue, seller agrees that the lockbox is for the seller's benefit, releases the broker. We already went over that. This releases a view of any liability and responsibility. Uh, this section here, withhold verbal offers, withhold all offers once seller accepts a sales contract for the property. So if the seller wants you to withhold verbal offers to agents or to withhold any information, you would select this here, withhold all offers once seller accepts a sales contract for the property. Um, Act as a transaction broker. So a transaction broker means you become a broker of the transaction when you are going to represent the seller, and you could represent the buyer as well. Okay. Virtual office websites. Some real estate brokerages offer real estate brokerage services online. These websites are referred to virtual office websites. An automated estimated market value of reviews. A virtual office website could be our own website where the properties are on there. The virtual office website may display automatic valuation of the property, comments, reviews about this property. Seller does not authorize an automated estimated of the market value of the listing. So basically on the MLS, when you go to input the listing, okay, it's going to give you some information at the end of the listing agreement, at the end of the listing, when you input it on the MLS, it's going to ask you these questions. And based on this conversation that you have with the seller regarding the estimate of the market value, if it's not authorized or it is authorized for third parties like Zillow, they don't want the property on Zillow, you would have to check this box off. All this information here, it's going to basically kind of give you less exposure on the property and the listing. I would recommend not to select this information, but it's good to know if you ever do have a seller that doesn't want their property address on the MLS, wants you to withhold offers, doesn't want you to use a lockbox system, or if you want to use a lockbox system. Basically, section 1 through 6 is going to give you price, your obligations, broker authority, what they authorize you to do. And here we're going to section 7, seller's obligation. Okay, in consideration of the broker's obligation, seller agrees to cooperate with broker in carrying on the purpose of the agreement, including referring immediately to broker all inquiries regarding the property's transfer, whether by purchase or any means of transfer. So if the seller is going to transfer the property to another name or another LLC, they have to advise the broker of this information. Recognize the broker may be subject to additional MLS obligations and potential penalties for failure to comply with them. So if the seller fails to comply, this could affect the broker. So if they change the name and you have a listing agreement with 123 LLC and they change it to 345 LLC, this could affect the agreement and your relationship with the board. You can get a fine. Inform broker before leasing, mortgaging, or otherwise encumbering the property. So if the seller is going to do a refinance, if the seller is going to lease the property, if the seller is going to do an addition, any of that information is very, very, very important for your seller to give to you. Identify the broker and hold the broker harmless from losses, damages, costs, and expenses of any nature, including attorney fees, from liability to any person the broker incurs because of: one, seller's negligence, representations, misrepresentations, actions or inactions, the use of a lockbox, the existing of undisclosed material facts about the property, a court arbitration decision that the broker who was not compensated in connection with the transaction is entitled to compensation from the broker. This clause will survive broker's performance and transfer of title. Okay, indemnify. Indemnify means basically hold the broker harmless. In other words, it gives you the breakdown right there of any damages, costs, and expenses of any nature, including attorney fees. So he's not holding you, the seller cannot hold you accountable for that. Perform any act reasonably necessary to comply with FRIPTA. So if the seller has any issue, is a foreign national, or he has any FRIPTA laws when he sells his property, the seller has to notify you. And also on the seller's disclosure, it asks you that question toward the end of the listing, toward the end of the seller's disclosure. Make all legally required disclosures, including all facts that materially affect the property's value and are not readily observable or known by the buyer. So if there's something basically that the seller knows about that affects the property's, okay, material or the property's value that are not readily observable, they have to let you know so that you can let the buyer know. Seller certifies and represents as the seller knows of no such material facts. So if they don't know of a building code violation, a lien, any of that information, or they do, you should specify it here. And also on the listing on the seller's disclosures, you want to get that information. So you always want to ask them anything in regards to the property and write it down. It's very important. Seller will immediately inform broker of any material facts that arise after signing this agreement. Consult appropriate professionals for related legal, tax, property condition, environmental, foreign reporting requirements, and any other specialized advice. Compensation. This is the good part. This is what we want to know in regards to get compensated. So whenever you're going to sign a listing agreement, I always have 6% here locked. 6% is the standard norm in Florida. A lot of agents will list for 4 or 5%. I would speak to your manager or your mentor in regards to this. I typically leave this number at 6, and that's where we'd like to keep it. Because if you do 6 and you pay the cooperating broker 3%, you get to you earn 3%, and or that is split 50-50. You could also break it down where if you get 6 and the market is paying out 2.5%, you can collect 3.5% for yourself. And I'll show you guys now a little bit in a few. Okay, seller will compensate broker as specified for procuring a buyer who is ready, willing, and able to purchase the property or any interest in the property on the terms of this agreement or on any other terms acceptable to the seller. Seller will pay the broker as follows. Okay, so the agreement for the commission is between you, the brokerage, and the seller. The percentage is of the total purchase price, plus if you want to add a bonus, if there's a bonus, you can add that here as well. No later than the date of the closing specified in the sales contract. However, closing is not a prerequisite for broker's fee being earned. Okay. The percentage of the consideration paid for an option at the time of the option is created. If the option is exercised, seller will pay broker such fee less than the amount broker received under his subparagraph. Okay. The gross lease value, if there's a leasing fee on the date seller enters into a lease, you can put a percentage here as well if there's a lease that's to be executed. Okay, broker's fee is due to the following circumstances. If any interest in the property is transferred, whether by sales, lease, exchanges, governmental action, bankruptcy, any means, regardless whether the buyer is secured by seller or broker or any other person, if seller refuses or fails to sign an offer at the price and terms stated in the agreement, defaults on executed sales contract, or agrees with a buyer to cancel and execute a sale contract, if within, I always put here minimum of 90 days, okay? Termination date period, seller transfers. So stating basically, if after those 90 days, after you have terminated this agreement, within those 90 days after termination of this agreement, they still owe you the commission, okay? The full 6% or whatever percentage you have placed here, which should be 6%. Seller transfers are contracts to transfer the property or interest in the property to any prospects with whom seller, broker, or any real estate licensee communicated regarding the property before termination date. However, no fee will be due to broker if the property is relisted after termination date and sold through another broker. So once you terminate your listing and the seller lists with another agent, that's basically a wrap. So you would have to, you can't go after your commission if once this agreement has been terminated and the seller goes with another broker. If you terminate this listing agreement and the seller sells it without a broker, you can be entitled to that commission. After within 90 days of the termination, you have a protection period. Retained deposits as a consideration services, brokers entitled to 50% if left blank. Okay. So a lot of times sellers there'll be buyers that won't perform. And if a buyer does not perform, the sellers from the deposit, from the 50% from the deposits retained from the escrow agent, the seller is entitled, has to give that percentage to the broker. Okay. Now, if the broker has an agreement on the purchase with another agent on the contract, that agreement with that agent has to revert back to this listing agreement. Okay. So here's cooperation with compensation to other brokers. Notice the seller. The buyer's broker, even if compensated by seller or broker, may represent the interests of the buyer. Broker's office policy is to cooperate with all brokers except when not in the seller's best interest, and to offer compensation in the amount of, this would be 2.5, or if you want to put 3%, you could put 3% of the purchase price, okay, to a single agent, okay, 3% of the purchase price to a transaction broker for the buyer. So if there's a single agent for the buyer, they could collect 3%. If there's a transaction broker for the buyer, it could be 3%. And if there's a percentage to a broker who has no broker's relationship with the buyer, let's say there's a family member and that family member is a cousin of the buyer, and the buyer calls you, but the buyer says to you, okay, I have my cousin that has his real estate license. If you guys are paying commission, I like for my cousin to represent me. So in that case, it would be the cousin representing that buyer. Or it could be vice versa. It could be a broker that has no relationship with that buyer. That typically is never the case, because there's always some type of relationship with the buyer. If you're a broker, obviously a lot of agents out there are working with buyers, and as you've noticed, buyers tend to be working with an agent on multiple showings on multiple properties, or they're working with multiple agents. So it's very important. A lot of the times this reverts to whose name is on that sales contract, what agent is representing that buyer at the showing and on that contract. Okay. broker's relationship. Broker will act as a transaction broker. Broker will deal honestly and fairly will account for all funds, will use skill, care, diligence in the transaction, will disclose all known facts that materially affect the value of the residential property, which are not readily observable to the buyer, will represent all offers and counter offers in a timely manner unless directed otherwise in writing, and will have limited confidentiality with seller unless waived in writing. So the broker's this section here is describing describing the broker as a transaction broker, and basically it's self-explanatory what your commitment is and how you will act and deal with the seller. Okay. Conditional termination. At the seller's request, broker may agree to conditionally terminate this agreement. If broker agrees to conditionally terminate agreement, seller must sign a withdrawal agreement, reimburse broker for all directed expenses incurred in marketing the property, and pay a cancellation fee of such amount plus applicable sales tax. So this section here, you want to always minimum $1,000. Let's say you spend $300 on pictures, they have to reimburse you for the pictures, and they have to pay you a cancellation fee or anything you spent regarding the marketing of the property. So if you put the property on Zillow ads, on Facebook ads, anything like that, you can be compensated back. Okay. If seller transfers or contracts to transfer the property or any interest in the property during the period of the date conditional termination to terminate and protection, if applicable, broker may void the conditional termination, and seller will pay the fee stated in paragraph 8 less the cancellation fee if seller transfers or contracts to transfer the property of any interest in the property during the time period from the date of the conditional termination to termination date and protection period. So within those 90 days that you put up there for protection period, if the seller transfers, does any of that information that just specified here, you can collect your 6% commission minus this cancellation fee. Okay, dispute resolutions. This agreement will be construed under Florida law. All controversies, claims, and other matters, question between parties arising out of the relating of to this agreement or breach thereof will be settled by first attempting mediation. Basically stating that if you guys, there's a dispute regarding the listing agreement, regarding the agent and the broker, it could first go through mediation and arbitration through the association, other mediator agreed upon by the parties. If litigation arises, which is a court, and it goes to litigation, out of this agreement, the prevailing party will be entitled to recover reasonable attorney fees, costs, unless the parties agree that the dispute will be settled by arbitration as follows. Arbitration by initiating the space provided. Seller, sales associate, and broker agree that disputes not resolved by mediation will be settled by a neutral binding arbitration in the county in which the property is located in accordance with the rules. So let's say a seller says, okay, I'm going to sell the property. You've done your job. They agree to this. You go to sell the property. You procure a buyer through the MLS with another agent, and now the seller does not want to sell. Okay, now the seller can be sued by the buyer and could be sued by the broker. We basically, if the seller signs this or initials this, meaning it would not be agreed that the dispute not resolved by mediation will be settled by a neutral binding arbitration in the county in which the property is located. Each party to any arbitration or litigation to enforce the arbitration provision of this agreement or arbitration award will pay its own fees, costs, and expenses, including attorney fees. So basically telling that whatever party is going to pay their own side of their expenses, their own attorney, and for their own hearings. Miscellaneous. This agreement is binding on the seller and brokers, heirs, personal representative, administrators, successors, and assigns. Broker may assign this agreement to another listing office. This agreement is the entire agreement between seller and broker. No prior or present agreements or representations will be binding on the seller or broker unless included in this agreement. Electronic signatures are acceptable, will be binding. Signatures, initials, and modifications communicated by fax will be considered as originals. The term buyer, as used in the agreement, includes buyers, tenants, exchangers, optionees, other categories of potential or actual transferees. Okay. If you have any other additional terms that you want to put on here, okay, if there's a bonus, if you get a full priced offer on the property and seller agrees to pay a $5,000 bonus, you can put that on here as well. Your transaction fee to lifestyle, it's typically on here. So seller to pay the $395 transaction fee for lifestyle, or I believe $495. You could also specify that on here as well. Basically have them sign, put their address, their phone number, their email address. Then here you would sign your information, the date, the address, and the date the copy was returned. You want to make sure the seller initials every page on this listing agreement, and you want to initial every page on the listing agreement as well. This is one of the most important things to be able to list properties and collect your commission. Your agreement with the seller is here, and it's very important to make sure the percentages are filled out correctly. You don't want to include missed a dot here or miss a dot there. You want to be very specific. I always have the 6% locked. You want to always have all these numbers filled out properly. So if you have 3% to the buyer's agent and 3% to the single agent or the transaction broker, you want to specify that here. If it's 50%, I always like to fill it out, even though this section here, you can leave it blank and it's going to be automatically filled. Any information that's left blank is just gonna can later on affect you. So the more you can fill it out, the better it is. I hope this training served you guys well. If you guys need any help for any listings or any properties that you're currently working on, you can feel free to email me. I'm gonna put my email here on the chat right now. And I'll be able to I'm gonna put my phone number as well. You guys can call me or email me. Enjoy the rest of your day and good luck to everybody.